All right, good afternoon, everyone in Hong Kong, or good morning or evening, depending where you are. Welcome to the Hong Kong 45 virtual Fireside Chat. My name is Calvin Chung. I'm a partner at PricewaterhouseCoopers in Hong Kong and a committee member of Hong Kong 45. Thank you for joining us today. Today's Fireside Chat is the fifth of the sixth session in our series to showcase the breadth of female talent in arbitration around the world. We had four wonderful guest speakers who have given us some inspiring talks in the previous sessions, and I'm sure today will be no difference. Our guest today is the Honorable Justice Crennan AC QC from Australia. I'm sure to many of you, Susan requires no introduction, but I will highlight a few of her remarkable achievements here. Susan is a former Justice of the High Court of Australia. She was admitted as a barrister in 1979 and was made a Queen's Counsel within 10 years of practicing, a time frame reserved only for the exceptional. She's the first woman barrister to be appointed chair of the Victorian Bar Council in 1993 and the first female president of Australian Bar Association in 1994. After her retirement as justice, she returned to the Victorian Bar as an arbitrator. We are very grateful that Susan has found the time today to speak with us. Susan will be interviewed by Wilfred Ho, a counsel from Skadden based in Hong Kong. Wilfred's practice focuses on international litigation and arbitration. He is a rising star in the practice, having been named as the practitioner to watch in a number of legal magazines in recent years. And both Wilfred and Susan are from Melbourne. Before I hand this over to Wilfred, please allow me some time to introduce Hong Kong 45. Hong Kong 45 is an organization for young arbitration professionals formed under the Hong Kong International Arbitration Center. Our mission is to promote interest in and knowledge of issues relating to arbitration and to provide opportunities for both professional development and social interaction. We organize regular seminars and career events. Since the COVID-19 outbreak, we have moved many of our seminars online, just like today. Please follow our LinkedIn page so that you know firsthand our latest activities. So without further ado, I will hand the session over to Wilfred. Thank you.
Thank you, Calvin, for your introduction. Before we launch into the interview, I would like to briefly share some of my own views on Justice Crennan and her significance to the Australian legal profession. As Calvin has noted, Justice Crennan is noted for a number of firsts. First woman barrister to be appointed chair of the Victorian Bar Council and the first female president of the Australian Bar Association. She was also appointed the second female justice of the High Court in my second year at Melbourne Law School. Her elevation was seen as a significant step in the right direction. To put this into context, a Conservative government was in power. Australia had both joined America in the Iraq War and rejected a proposal to become a republic. Not exactly a time for change. It was an exciting and empowering moment for students and the profession at large. Some of my friends even threw Crennan parties. Needless to say, Justice Crennan's appointment was more than symbolic. Long before her appointment to the highest court, her intellect and ability had been well recognized. She was officially anointed living legend of the bar by the Victorian Bar. On that occasion, she was described by the other legend of the bar, Justice Goldberg, as very much a Renaissance woman with a passion for English literature, Old Norse, and Anglo-Saxon, and not necessarily in that order. During her time on the High Court, Justice Crennan authored more than 300 judgments. All of them are significant, but the landmark judgments of Roe and Electoral Commissioner on electoral franchise, and Williams in Commonwealth of Australia on executive prerogative and expenditure stand out. In relation to Roe and Electoral Commissioner, Justice Crennan's background as a constitutional historian particularly informed her recent judgment. One of the features for which she will also be remembered is her respect for all arguments, no matter how polished, and for the parties presenting them, for the human condition. Justice Crennan is also recognized for helping to instill a tradition of collegiality and the writing of joint judgments on the High Court. Perhaps more so than other common law courts, except for the United States Supreme Court, Australian High Court judges tend to write judgments separately. Justice Crennan supported the use of joint judgments to promote collegiality, often to the perceived expense of her own individuality, at least according to the commentators. She is a team player, and as the current Chief Justice of Australia has remarked, collegiality is not compromise. With those final words, let us begin. Thank you, Justice Crennan, for joining us and sharing your insights.
Thank you for the invitation.
You have a storied career in both education and law. What led to a career in the law?
Well, I was an accidental lawyer, really. My first degree was in English literature and language, and the language side of it was considered a relevant qualification for becoming a trademark attorney. And that was my first job after graduation, was to become a trademark attorney, where I utilised some of the skills acquired during that first degree. And I realised that to go on to be a fully fledged patent attorney, I would either have to undertake graduate then postgraduate work in science or engineering, or I thought in a light bulb moment, the easiest thing perhaps is to do a law degree, which was very appealing to someone who'd come from the humanities side of the disciplines anyway. And so that's entirely what I did. I started a law degree part-time, converted to full-time. And whilst I was studying law, I taught English literature at the year 12 level, which is senior high school, and ultimately finished up in the way you've described.
Did you think there were similarities between your career in education and your legal career?
Sorry, I didn't quite catch the first part of your question.
Did you think there were similarities between your career in education and your legal career?
No, not really, no. I mean, my teaching career involved exclusively the teaching of literature. The subsets there were poetry and fiction. The emphasis was on the 19th and 20th century. So it was really a very different area of discourse, very different skill set from being a lawyer.
Perhaps I may move on to the next question, which is of some personal interest of mine because it concerns the first Asian Australian barrister, William Maquette. And this concerns a conversation between Joan Rosenov QC, who was the first woman in Victoria to sign the Victorian Bar Roll. And she recalls a conversation between her and William, where William says to her, Joan, you and I have both chosen the wrong profession. We will never satisfy our ambitions. Neither of us will ever be made a judge, you because you're a woman, I because I'm Chinese. We should have done medicine. It is obviously gratifying to see that William Maquette has been proven wrong, clearly with your example and others. Nevertheless, what are your thoughts on William Maquette's observations?
Well, I think they were very apropos at the time. Just to give it a context, Joan Rosenov, who, as you say, was the first QC at the Victorian Bar, I was the fourth. She was 49 years older than I was, so she took silk late in her life, late in her career in 1965. At the time, I was doing second-year arts, studying literature. So there's a big chronological gap there, but very similar interests, of course, in a professional sense. I think what needs to be said, I guess, is that diversity just wasn't a cultural concern that carried the tremendous weight it does today in her time, and she suffered from that. So she didn't get the benefit of the impetus that was given to that concern. I think if you ask me to locate when that first arose, well, of course, there were philosophers like the French philosopher Michel Foucault, who was very interested in the whole question of diversity and cultural norms, social norms. And I think the whole movement, which is perhaps now over, but the intellectual movement that sometimes people call postmodernism, had a lot to do with opening up ideas socially about diversity, and I've got the benefit of it. And regrettably, Joan Rosenov, who I think was immensely talented, didn't get the benefit of it to the same extent. And William Maquette was quite perspicacious, I think, in his remarks.
Now, this might be an impossible question, but are issues of diversity, in your view, more or less acute in the law?
Than earlier?
Oh, than other professions.
Well, I can only really speak about the law. I think a great deal of change. Well, you mentioned that I went to the bar in 1979. For a lot of people, that's a long time ago. Indeed, for me, it's a long time ago. And so I have witnessed palpable change in terms of diversity in the representation of women at all levels of the profession, including the judicial level. When I went to the bar in 1979, to be a female barrister was an odd thing. One stood out because the numbers were so low. That's no longer the case. I don't know if you have the same system in Hong Kong, but we do have the same system as England. So a QC will go along to court with someone who is called a junior, who hasn't taken silk. And so I never, ever was led by a female silk. And I did know the very first judge on the High Court, and I appeared in front of her, but that was a novel experience. I appeared in front of her as a silk. In my time as a junior, there was an absence of women on the superior courts. So I'm talking 1979, I took silk in 1989, so there's one woman on the High Court. Ultimately, I became the second. Very few women practitioners, but now that has all changed. I think the figures now would put women at the bar at about around 50%. Women, of course, are on many of the courts. And speaking for myself, I know many women on superior courts right around the world who are women. So I think the depth and breadth of change has to be appreciated. It's been remarkable, it's been palpable, and it's been quite a privilege in some ways to be part of it and to witness it.
I think that leads on to the next question, which really deals with the challenges of the bar that you might have faced. At the International Women's Day breakfast event hosted by the Governance Institute of Australia in March earlier this year, you discussed in depth the general unwelcoming environment for female barristers in the 1970s. There was a gender pay gap, only 5% of barristers were female, and many of them were resigned to having a nominal career or one in certain specialist areas only. If I may appropriate a joke that you told at that event, although I won't tell it, you mentioned that it was popular among female barristers at the time to comment that life at the bar required an understanding of life pre-Czech Republic. Do you think things have changed?
Yes, I do think things have changed. That was the joke I told was really a joke I heard in the 90s. And one point I was making in more recent times is that as we witness the evolution of greater and greater numbers of women being educated in the law and having the ability to come to the bar, one of the themes in discussion was rancor, quite a bitter feeling, if I can put it that way. And it was a theme for quite a few decades. And the point I was making in more recent times is that the progress has been so great and so palpable. I'm not sure rancor is all that useful these days. Everybody knows it's not good for the soul anyway, but of course it's a spur to ambition. It's a spur to right or to redress something that's not properly balanced. So it has its place. But that was really the point of me talking about a mildly rancorous joke, and a good joke, from the 1990s in the context of the present.
I haven't said the joke, so would you like to say it, or shall I?
Oh, well, I can't perfectly remember it, so you can.
So the joke apparently is a male barrister goes to heaven and at the pearly gates St. Peter says, to get in you have to pass a spelling test. And the male barristers pass the test easily as they only need to spell God or man. While a female barrister goes to heaven, St. Peter says to her at the pearly gates, you must pass a spelling test. She says, okay. And St. Peter says, spell Czechoslovakia.
Yes, that was told to me by a Canadian woman, a professor of law. And it's a good joke because it's got a great punchline.
Now, wading into a more controversial area, and you've touched on that topic previously, which really relates to women judges and judges or female representation on the judiciary. And you mentioned your time appearing before Justice Mary Gordon in the High Court. And this is slightly more controversial, but you may be aware that Lord Sumption made some controversial comments in 2015 to the Evening Standard regarding the role of women in the English judiciary. And I'm going to cite some of those comments for the benefit of the audience, but he said that he believed the judiciary was a terrific public asset, which could be destroyed very easily if the selection of candidates was skewed in favor of women. To avoid inflicting damage, campaigners for equality would have to be patient, and suggested that it would need up to 50 years before the number of women on the bench matched the total number of men. It was rubbish to say that the law was run by an old boys network, and insisted that the lack of female judges were mainly the result of lifestyle choice by women unwilling to tolerate long hours and poor working conditions. Now, I don't know whether this has been reported accurately, obviously, but it was certainly reported in the news, and it would be fascinating to get your views on his comments.
Well, the first thing I would say is that Lord Sumption has, and this is very well known, intellectual interests outside the law. I think that's best illustrated by the fact that he's written quite a magisterial history of the 100 Years' War between England and France. And I think, like many historians, he's rather averse to oversimplification of human affairs. And I think you need to understand that when you're looking at what he's saying. He takes a long view of the present, I think, and is deeply conscious of what's happened in the recent past. And I mean, I won't speak about the UK, obviously, and comment on that because I'm an Australian, but speaking of the Australian experience, to which I think he's adverting, the position of women in the legal profession and certainly in the judiciary in the 1960s in Australia was very bleak. There were very few of them. But I've already mentioned to you that that was the position when I became a barrister. I was the second woman on the High Court. Now there are 3 women on the High Court, and there are many women on the superior courts, both in the civil law countries and the common law countries. So the change has been remarkable. So that would be my reaction to what Lord Sumption is saying. I mean, he is a man who is interested in pointing to, how shall I put it, verities in a very complex situation. And that's how I think his remarks should be seen. I think also, if you think of Lord Sumption as I do, as a man who, in a sense, has a fastidious distaste for enemies of truth or harmony, everything he says is perfectly understandable, I think.
Thank you. And maybe on to the next question, which you mentioned that Lord Sumption obviously has interests outside the law. You know, what are your interests outside the law? We obviously know you are a Renaissance woman. And do you think they've made you a better lawyer?
Well, I've already mentioned my first discipline was in literature. When I was a young silk, I went back and did some postgraduate work in history because I'd always liked history. So I do have, I think it's fair to say, strong interests outside the law in the sense that they are interests I spend a lot of time on. So certainly I've remained, since I was an undergraduate, greatly interested in poetry and fiction. I'm very interested in biography. I would probably read a biography once a fortnight or so. I have remained interested in French. I'm not saying I'm talented at speaking in French, but I've always had a very strong interest in French culture, French art, French novelists, French literature. I'm interested in art and have children who are quite interested in art also, so that's a great dimension to life. I'm interested in music. I'm interested in, particularly in the voice and also the cello, which has been played by successive generations in my family and includes a couple of my grandchildren. So yes, if you're talking about are there things outside the law upon which you spend a lot of time, the answer is yes. One interest I should perhaps mention, because I think women who've been judges on superior courts wouldn't necessarily mention this, but I'm a fanatic about cooking. I love cooking. I would own hundreds of cookbooks, and all my life I have been very interested in it. I've even written a cookery column in my early years for a provincial newspaper. And I used to find it very good relaxation. If I had a difficult cross-examination coming up, I would prepare an elaborate 3-course meal while I had to cogitate about these things. So I do have a
very lucky for your guests.
I hope so. I hope so. So there you are.
Thank you. So the next question we had, which is one of the key themes of the HK45 Fireside Chats, is about mentorship. And it really, you know, the next question I'd like to ask you about is, who are your mentors? I obviously know that you read with the formidable David Bennett, if I may describe him that way, who was Commonwealth Solicitor General. I think you also described as his protege. You know, how have your mentors helped you in your career, and do you think they're important?
I do think mentoring is important. It's particularly important in advocacy, because advocacy is a very, bit like being a good actor. It's a very mimetic thing. One learns a great deal from watching an exceptional advocate. And so the mentors I had, and certainly David Bennett was one of them, and the Silks generally, who took me to court when I was a junior, were always very generous with their time, both discussing the legal problems and also showing me by demonstration, rather than talking about it, how to be a good advocate. So they taught you by demonstration, really, the virtues of being succinct, the virtue of answering questions from the bench in a way that was satisfactory, the virtue of homing in on what a problem is really, rather than getting caught up in superfluous matters. All these things are the virtues of truly great advocates, and the easiest way to acquire them is to be an observer of those who can demonstrate them. And I hope in a very minor way I might have been able to do the same for my juniors.
So what are the biggest changes that you have observed in Australian litigation over your career, and perhaps first as a barrister and then as a judge?
Well, I think, I think there's been, in the last 20 years or so, a great deal of emphasis on efficiency in procedures, and that's well placed. So I think, you know, people often talk about the differences between arbitration and litigation and say that arbitration is more efficient or is conducted more quickly or whatever. I think courts have put a lot of effort into making sure that they don't let their procedural aspects get bogged down and create a big gap between the initiation of proceedings and their conclusion. So that's been a change for the better. Certainly there's been in modern times always a very appropriate concern with access to justice. So the burgeoning of pro bono instrumentalities, including pro bono work at all the bars, England here, and I dare say Hong Kong, that's a very good development. I think, I mean, it sounds a bit valetudinarian, and I know older people often say this, and I used to think I'm never going to say things like that, but times were simpler, certainly when I first started at the bar, and I'll just take contract principles as an example. The contract textbook you could master, and then you could have a client come into your chambers with a contractual problem, and you could give a fairly confident answer about the outcome of litigation, success or failure. After then, we had developments like equitable estoppel would be one example, but many, many developments in relation to restitution or misleading and deceptive conduct, all sorts of things, meant that life became more complicated. It wasn't quite so straightforward to make confident predictions about the outcome of litigation. Litigation itself became very complicated, or more complicated, I should say. So they are changes. They're natural enough, I think, and neither to be. Well, I think they're all changes in the right direction, I suppose, or they're either in the right direction or inevitable anyway, as times have become more complex.
And this relates obviously to your comment about the fact that times were simpler, but you were described by a fellow member of the bar as one of the last generalists that can tackle any area of law. And this is obviously of some interest to me because I think in the Hong Kong context, it's still very much the case where legal practitioners can largely be described as being more generalist. You know, what in your view are the advantages of being a generalist?
Well, one is interest. If you've got a capacity to be bored easily, having new challenges all the time is a very good thing. Because I went to the bar with intellectual property qualifications already, it meant that I naturally was going to be doing the patent, copyright, trademark work. And it was extremely interesting because it's often at the cutting edge of what's happening in society. You know, inventions are obviously made in response to a need. And so that was interesting, remunerative, and also a portable specialist qualification because I worked in both America and England in relation to my patent practice. But it was very pleasant to be able to leaven that with constitutional work, public law work, criminal appellate work. They all had their own very special interest. And I think if you can practice in a general way, count your blessings. It's a good thing. And it does mean that you probably have to work very hard all of the time because you're not just in a repetitive, narrow landscape, but that's no bad thing. There is a room, of course, for specialisation, and I think it's very popular. And certainly even when I was practicing patent law, there were patent lawyers who did nothing but intellectual property work and did it extremely well, and they were very formidable opponents for me because I did other things as well. So there's no one correct way of doing it, but certainly I appreciated having a general practice. And if that's what you're doing in Hong Kong, well, good luck to you. You're lucky. Count your blessings.
Indeed. So you retired from the High Court 5 years ago and stepped into a busy practice as an arbitrator and mediator. What are the differences you have found between acting as an appellate judge and an arbitrator?
Well, one thing they have in common is they're both time limited. You know, you cannot conduct appellate advocacy except in a time constrained way. So you have to be you have to use the time you have very effectively. I think there's a very similar imperative in the arbitration space, which reflects the finality of arbitration, because there is no appeal except in very exceptional circumstances. Again, there has to be the ability to concentrate absolutely on the issues at hand. The differences, I suppose, well, in a trial, in normal litigation, there's the luxury of getting into the facts in a way that's quite deep, which is not always available in an arbitration. But that, I think, just puts the responsibility on the advocates in the arbitration to make sure they are going to be able to present the facts in a digestible way. So it's not exactly a limitation, it's a difference which everybody involved in the process has to come to terms with and has to make sure it is dealt with. I think in appellate advocacy, all the great appellate advocates, I think, can very effectively present a complex point in a very succinct way. And that kind of skill, I think, is also often very relevant in an arbitration where there may be very complex technical issues which have to be understood by the arbitrators. And so for advocates to have the ability to be able to present that complex material in a succinct and concentrated way is a necessary part of the process. So there are more analogies than differences, I think. The biggest difference is the one I've already mentioned, and that's the difference between the way you deal with facts in litigation and the way you deal with facts in an arbitration.
So one of the topics that I wanted to raise with you is about the debates that have raged over the past decade between arbitration as a threat to legal systems which rely on judicial precedent. And on the one hand, you have Chief Justice Keen's comments, which he made in 2010, and he says considerations of principle concerning the public interest are not in play in the case of arbitral decisions because of the interior agreement of the losing party to be bound by the arbitrator's decision. And then on the other hand, you have Lord Chief Justice Thomas of England and Wales stating in 2016 that in the right case involving legal issues, it would be better determined in a court because more importantly, the wider interests of their industry, that's a specific industry, and the common law in general would be much better served by more issues being resolved in court and the law thus developed and clarified. What are your views on this? Do you have a fixed view on it, or are you more agnostic towards this arbitration versus litigation debate?
Well, there are obvious differences, and I think they go back to the fact that litigation is run by open and state courts, and arbitration is a private choice of the parties. Of course, it's true that the highest court in an appellate tier is the right place for legal principle to be altered in some way in a precedential common law system. But that doesn't in any way inhibit arbitration. Arbitration is a private matter. My observation anyway as an arbitrator is that what's attractive to those who seek an arbitration rather than litigation is not that it's more efficient or cheaper, it is rather that it is confidential and parties, say on a major piece of infrastructure or a transnational arbitration, may value that for a whole range of reasons. It's the confidentiality and it's the finality. It's the ability to choose your judge, or I should say your arbitrator, from a huge pool from all over the world, so you can actually think very hard about the issues that need to be determined and who would be suitable to determine them. There's the freedom from the constraints, if you like, of perhaps local laws versus the laws of a seat of an arbitration or something of that kind. And then, of course, there's the enforceability of the awards under the New York Convention. So they are very different animals, really. I don't think one's better than the other or one is preferable to the other. I think they both serve purposes in our society. Of course, the state courts are extremely essential for the public administration of the rule of law. Arbitrations are also very useful in the commercial context, where the law that is decided by the courts is applied to all sorts of complex facts in a way that has a finality and an enforceability desired by the parties. The other factor I should mention, of course, which is common to both the litigation and arbitration, is the fairness aspect. That's very critical in both.
Turning to advocacy, in 1990 you were appointed senior counsel assisting the Royal Commission into the collapse of Tricontinental, which was a $2 billion corporate disaster. The issues were particularly complex and difficult. It was said that being cross-examined by you is like going up against some of the all-time greats of Australian rules football. And I think for those in the know, it was Gary Appellate who you were compared with, and his nickname was obviously God. Could you share with us your experience on this case, and in particular the advocacy aspect?
Look, the Royal Commission was into a banking failure. I had two juniors. Like any Royal Commission, there were time limits within which the investigation was to be conducted. So far as what struck me most about the Royal Commission was that world economy moves in a very cyclical way, and in high boom times there's a lot of lending, and in more recessionary times, when that lending is examined, it is possible to see that it perhaps didn't conform to the prudential constraints that apply rigorously in times which are not boom times, recessionary times. So it was a great eye-opener about macroeconomics. What stood out, and it's been very important for Australia, is that capital adequacy of banks is extremely critical in lean times or recessionary times. And that aspect of banking was strengthened after that Royal Commission in Australia. And certainly there are some who take the view that that was one of the elements that helped Australia weather the global financial crisis we've had, the most significant since starting in 2007, if I recollect correctly, because the whole inquiry was in response to a global financial crisis in 1989. So it was a very interesting inquiry. I had two juniors. They did more cross-examination than me, as I recollected. And it was a very interesting experience.
What characterizes effective written and oral advocacy in your view?
Being succinct, I think, is one of the things I would most urge. The other tip, I think, is resist the temptation, and it's an interesting temptation, but resist the temptation to show the reader or the addressee everything you know about a legal topic. It's not really helpful necessarily. I'm not trying to dissuade people from making sure they do their research carefully and so forth, but it's the submission that is short, that is to the point, that is well written, no showing off, succinct. These are all the things that make good advocacy, whether it's oral or written. So far as oral advocacy is concerned, I think the most important thing, apart from being succinct and not getting distracted, is to be able to answer questions, and to do so in a way that is not waffly and not glib, but is actually quite comprehensive. So you're able to say, well, there are three answers to that, and off you go. So it's really, I used to have a little motto, and it was really taken from boxing, but I used to say it to my juniors when they would complain about all the work I was asking them to do to prepare for a case. Anyway, cutting to the chase, the motto was train hard, fight easy. So I think the secret of good advocacy and great advocacy is preparation. The better prepared you are, the better advocate you will be. The more you're on top of the facts, the more you're on top of the relevant law, the better advocate you will be, and the better results you will obtain.
Thank you. The next question that I had was about Asia Pacific and Hong Kong. Based on your own experience in the development in the Australian legal industry, do you have any observations for a developing and vibrant jurisdiction like Hong Kong?
Well, I think every country, every jurisdiction has challenges which reflect the times always, to be flexible enough to be able to respond to them in a way that's accommodating and fair and doesn't betray a closed mind about we need to do everything the way we've always done it and all that kind of thing. That's something that needs to be borne in mind, I think. I mean, it's a big question, isn't it? Because it throws up cultural, social, economic, all sorts of dimensions to it. And I wouldn't presume to be an expert about any of those things. I'm only speaking from my own experience, having observed a fair bit of change over the last 40 plus years. I think one of the things that we appreciate here in Australia is the ability to be able to thrash out differing points of view, especially with social change. I mean, I said before, I think that some people didn't think the numbers of women in the judiciary were sufficient yet. Others, like Lord Sumption, had a different point of view. I think for all societies, including Hong Kong and Asia, being able to accommodate the differing views and work out a step forward, let's put it, that seems to command a consensus and so on. They're the sort of challenges we all face. We're all sort of in it together. I mean, I think COVID-19 has been a good example of how there are differing points of view about how best to deal with it, but there are at the same time pressing imperatives. And it's a good demonstration, I think, of the way in which we do face challenges from time to time, right out of left field, which we could never have anticipated. And it's good if our civic setup has got the flexibility to be able to accommodate them in a way that is best for both the individual and the societies as a whole.
I've got one final question for you, but before I do so, we'd like there's a panel for the audience, for people attending, there's a Q&A panel at the bottom of your screen. And please feel free to raise any questions just before we launch the last question so I can deal with it after. But the last question I had for you, Justice Crennan, was who, living or dead, would you like to have dinner with and why?
Okay, well, I said before I loved reading biographies, and I'd have to admit there are lots and lots of people past who I'd like to have dinner with. One of the top ones I'd nominate would be Anna Akhmatova, a Russian poet, a very, very interesting woman. But I'd prefer, I think, in terms of your question, to think about a dinner with lawyers in the here and now, where we can reflect together on some of the issues you've asked me about, where we could take the pulse, if you like, and have a bit of a think about how best do we navigate our future. So in that context, and I know all three of the guests I'm going to invite, although I've only had dinner before with one of them. When I say no, I have met all three, don't know them well. So my first guest, I think, would be Christine Lagarde, who, and we're all lawyers at this dinner, Christine Lagarde, who now heads the International Monetary Fund. But when I first met her, she was moving from being a managing partner at Baker & McKenzie, which of course is a global firm, to French politics. But I think she would have some very interesting views about the here and now. I think I would invite Jeffrey Ma, who you'll all know very well, because I haven't seen him for a few years since he was last in Australia. So I'm there. So there's 2 women, 1 man. I think my final guess would be Jonathan Sumption.
Brilliant. That's a great answer. I haven't got any questions from the audience, so I think we may be able to wrap up.
Okay.
Thank you, Justice Crennan. It's been extraordinarily insightful, and thank you so much for your time.
Thank you for the invitation. Thank you.
Have a good evening.
You too.